Good morning, everyone. Welcome to today's webinar. I have the pleasure of being here with Andrew Black with KBR. So for myself, my name is Rafael Aquino with Affinity Management. We're going to give everyone about a minute to log in. We have over 300 participants that have registered to today's webinar. So we want to make sure that we get everyone started together. We are going to be going over today's topic, which is the screening process, how to develop procedures and train your screening committee. We will do our best to answer any Q&A. So at the bottom of your screen, you should see something called Q&A. Feel free to put your questions that are related to today's topic. Andrew and myself will do our best to get to those questions. We'll go through the slides first, and then we'll do our best to do a rapid fire and try to answer as many questions as possible during today's webinar. So again, for all of you, those of you just logging in, both managers as well as board members, we're going to be going over the screening process. We're going to give it just about another 30 seconds to let the participants log in. We want to make sure when we get started, we have everybody on board. We have over 300 people that registered for today's webinar. So it takes about a minute to get everyone on board. If you're just logging in and you have any particular questions with regards to today's topic, please kindly use the Q&A at the bottom or the top of your screen, and Andrew and myself will do our best to get those questions answered. I'm sorry. So Andrew, I think the numbers have gotten pretty steady there. Why don't we get started? Why don't you introduce yourself, say a little bit about yourself and the firm, and then I'll go next.
Absolutely. No, I want to thank you all so much. My name is Andrew Black. I'm with KBR. I am a board certified condominium attorney. Our firm, primarily, I would say 95% or more, our client base are condominiums, HOAs, co-ops, any sort of community. And we are throughout Florida, really a full service community association firm. So any issue at all that impacts your community, whether it's reviewing contracts, enforcing rules, collecting past dues, general corporate law, construction defect, really any matter that may impact you all. That's what we do really each day. We have 3 primary offices, 20 attorneys, so we're fully staffed. And really, I want to thank you all. You all could be doing lots of things at 11 a.m. on a Wednesday. So the fact that you decided to spend an hour with us, I sincerely appreciate that. And Rafael, back to you, and then we'll kind of jump right in.
Thank you, Andrew. And I couldn't agree with you more. I'm definitely appreciative for all the board members and managers that are on today's webinar. As I say in most of my webinars, it says a lot about you as board members and managers that you're taking the time to gain some additional knowledge, gain some additional education. It says a lot about you and your leadership skills and what you're doing for your community. So I wanted to applaud you for that. As for myself, my name is Rafael Aquino. I am the CEO and co-founder of Affinity Management Services. We are a community association management company. Our core area of focus is Dade, Broward, and Palm Beach County. We're more of that boutique style operation. Our ideal client are clients that are really looking for that personal touch, being able to have access not only to just the regionals and all the resources that you get with the larger organizations, but really being able to have a chit chat with the owner, knowing that someone's there to support them and guide them through whatever challenges they may have. So with, I guess, enough about us, why don't we get started with what most of the board members and managers are here to gain knowledge on. We do have some quick questions. The videos will be posted on our YouTube page. We'll give that information at the end. And I'm sure Andrew wouldn't have any problem sharing it with anyone. So with further ado, Andrew, why don't you take it from here?
Awesome. Thank you all. And just right off the bat, just so you all know, I like to be a little informal. I'm not going to be reading line by line of what the outline says. I really want to focus on really the practical legal issues that our firm sees on a day-to-day way. Rafael, certainly from the management, he's got a lot of good, valuable insights as well. But really what we're talking about here is the ability to screen, to review and approve someone that wants to move in, someone that wants to buy. And just the first item is defining the role, right? And the very first sentence, I want to take some time and I want to share sort of an anecdotal story. And that first line is evaluate the authority in what your governing documents say. This is really important, and this is really the lens that I want you all to view this, whether you're on the board, a manager, an owner, someone who's thinking about running for your board, is the authority in the governing documents. Your governing documents are unique to your community. There is not one set that governs every condo or every HOA. I wouldn't have any idea what your governing documents say. So it is crucial that you review them. Specifically, do we even have the underlying authority to be involved in the sale lease approval? I think there's a misconception out there that there's some statute somewhere that just allows boards to approve someone that wants to buy or wants to approve someone who wants to rent. And that's not the case. Your governing documents must give that authority, okay? And it's not just a board rule, okay? The governing documents are the declaration of condominium if you're a condo. If you're an HOA, it's something called the Declaration of Covenants and Restrictions or something along those lines. But that's where this approval authority needs to be. And I always share this story when my wife and I, we were looking to buy our first home. And maybe I'm jaded from practicing this type of law for so long, but I thought maybe condo living isn't for me. Maybe even HOA living isn't for me. Let me try to find a single family home that there's no association at all. And we know in Florida that can be very tough. So we settled on a beautiful small HOA. We get a closing date set. The documents, I get them. And just like I know you all did before you bought, you read them line by line, right? And you knew what was in there. And I specifically read whether I needed to be approved or not. And they had a section in there. It was in their covenants that said something like sales. And all it said is that if an owner wanted to sell, the owner needed to give a copy of the sales contract to the HOA. Basically just to update the owner roster. There was no approval rights. I said, okay, I kind of chalk that up. We, me and my wife, anyone who's bought a home knows it can be somewhat of a stressful process. And the bank loan got approved. We're all excited. And then let's say closing was scheduled for a Friday. Wednesday afternoon, our real estate agent sends me a text at work. And I'm thinking, this is strange. She's been dealing with my wife every day. This must mean something's wrong. And she doesn't want to tell my wife. She wants to tell me, and then I have to tell her. So my real estate agent says, Andrew, the property manager just called me. You and your wife need to be approved. And they're not going to give the certificate of approval until you go through that process. And I thought, okay, how do I want to approach this? Their documents don't give them sale approval authority. But I'm not playing Mr. Attorney. I want to buy into this beautiful HOA. And I know management, and Raphael can attest to this, they're the authorized agent of the HOA. So it really isn't coming from the management per se. It's probably the board who just thought this is what should happen. So I drafted what I thought was a very pleasant email to the manager, thanked him for really a very tough job. Management's on the front line, right?
Yep.
Thanked him and said, I'm happy if you want to run a background check on me. There's nothing in my criminal past. However, please do let the board know that their declaration doesn't have sale approval rights. So if they interfere with this sales transaction, there may be legal recourse being filed, and the manager called me right back. and I give him a lot of credit. He said, Andrew, you're the first person in 10 years that's ever read the documents and essentially called this board out on their lack of approval rights. And this is sort of a long-winded anecdotal story, but I think it's important. If you're a manager or you're on a board, you should be 100% sure what your declaration says about sale approval and rental approval, because that's the first step. If you don't have that authority there, you can't even involve yourself in the approval process. So I always like to share that sort of anecdotal story. And a little post note, we've been in our HOA for years now. It's wonderful. We put our trash cans out on time. We pay our dues on time.
Did you invite your current board?
Yeah, we invite the current board. So it's been, great. But I do think that's an important thing. And, lots of owners maybe don't realize, but those governing documents, that's a contractual agreement. It's binding. So without the rights in the contract for the board to approve a sale or to approve a lease, you don't have that authority. And I want to just touch base on just something real quick. And I'm going to kind of jump around here. And again, this is all really good stuff, but I want to also just touch base quickly on, even if you have authority to review a sale or approve someone who wants to rent, oftentimes we get questions of, Andrew, John Smith from Unit 101, he just executed a quit claim deed or just a transfer to a third party. And so it's not a sale. There's no sales contract. There's no money exchanged. It's just a transfer of ownership. Maybe your buddy from college hit the lottery, got lots of money, and he wants to give you a gift. And the gift is a condominium. There's no sale there. So it's important just to know, if you're involving yourself in the approval process, how wide is that authority? Does it include sales, any transfer of ownership, a gift, a quit claim deed? Oftentimes, if someone passes away, there's someone will acquire property by an inheritance, a will. Does your documents allow the board to involve themselves in those types of transactions as well? So I just wanted to kind of point that out. Okay. And I think it's important to get into a little bit of the actual application process. And I know management deals with this process a lot.
Yeah.
So we talked about the underlying authority needs to be in your governing documents to even approve it. Another item that you need to be made aware of and your documents need to say is, what is the time frame that the association has to review and render its approval or not? The documents could say 30 days is pretty common. I've seen 15, I've seen 10. 10 days is not a lot of time. I've seen 45 days. So I think that's a key fact that you all should be aware of. And there should be an intake process. When you get the completed application submitted, that date should be logged in. Certainly you will utilize oftentimes a third-party background company to run the criminal check, to run the financial check, and I'll get into some of the good cause factors that a board could possibly use to turn someone down. But you want to make sure you know what that time frame is, because most often there'll be language in your documents that will say something along the lines of, if the decision isn't rendered within, let's say, for example, 30 days, then the application is deemed approved. And you don't want to get into an argument over, well, it's been 31 days, we didn't issue our decision, and now you have an unhappy owner who says this transaction is now approved and you can't do anything about it. Also, on the application side of things, and also I probably should have said this before I got started, The way I usually go about it is I'm going to go through probably another 10 minutes or so, and then we'll get questions at the end. I want to leave lots of time for that. So if you do have a question, again, use the Q&A. But part of the application process, right? You want to know how long you as a board have. Also, what fees can we charge? And Raphael and I were speaking on the phone earlier, and for condominiums, there was a change in the law, change to 718 of the Florida statutes. That's the Condominium Act. What that change says is for application fees, whether you call it a transfer fee, a screening fee, it used to be $100 maximum. It's been $50 increased, so $150. Condo boards now, as of July 1st, can charge an extra $50, so $150 is the maximum, all right? But the key point is the ability to charge that transfer fee, your governing documents must allow it. It can't be by just a board-made rule. So some documents, I've seen it, it'll give the boards the authority to approve a sale or to approve a rental, but there isn't that corresponding authority to charge that transfer fee. So if that language isn't in your governing documents, the boards does not have the authority to charge that. And we've seen all sorts of boards get creative and try to charge other types of transfer fees, and they'll call them all sorts of things. And the bottom line is, if you're charging a non-refundable fee as part of the application process, $150 for condominiums, that's the maximum. We include an article, it's a bit, I think it's about from 5 years ago or so, but there was a class action lawsuit actually filed in Miami-Dade County against various condominiums that were charging all sorts of non-refundable fees in connection with the application process. So you don't want to get caught up in that. All right. The other type of fee that is authorized, and we see it a lot, but again, your governing documents must provide for it, is a refundable security deposit. And that's for lease agreements, obviously, not for sales. But if your governing documents allow a security deposit, the law does allow associations to charge that. The way it works is it's a maximum of 1 month's rent. So when you get a copy of the lease agreement, you see what that monthly rental amount is. And if your documents allow it, you can charge that security deposit up to that 1 month's rent. Remember, it's refundable. The security deposit has to be kept to protect against damages that the tenant may cause. All right. It's not to be used if the owner doesn't pay his or her dues on time or some other charge. It's for if there's damage during the rental agreement, the association can make a claim on that security deposit. And there is a statutory form, a statutory process. It's essentially, it's in the landlord-tenant statute. So the association is acting as the landlord in that instance to make a formal claim on the security deposit. And if there's no damage, associations are supposed to return the security deposit when the tenant moves out. I've dealt with some clients that have told me they have unreturned security deposits going back years. So you don't want to do that, and you're going to have to discuss with your counsel. And also, I want to point out, and usually I do this at the start as well, what Raphael and I are going over today, this is just general information. So my attorney disclaimer is, this is not legal advice. I don't want you to go back to your board and say, I met with an attorney. We have the authority to do X, Y, and Z. That wouldn't be an appropriate thing. These things are very fact specific. So you definitely need to get with whoever your current counsel is.
Andrew, if I could jump in here on the security
Sure.
deposit. So further, one thing that's very important that sometimes when we're onboarding new clients, we're looking for certain things such as what you stated, can they permit rentals and so forth. But also another crucial point that we're looking for that a lot of times for some reason it gets missed is making sure that those security deposits are actually in a separate account. It's
Great.
very important that you're managing that in an escrow style of an account. And that you have schedules that outline who those security deposits are for. The reason being is that whenever the request is made, you're going to want to cross-reference to make sure that that security deposit was provided and when it was provided. Further, you got to understand what that security deposit was for. Is it for moving in, moving out, for damages? And then you have timelines tied to when you can provide you have 10 days to provide that security deposit back to that individual. So as soon as you kind of know that someone's going to be moving out, there needs to be a request made, and then that money should be removed from that particular account. So I know that when we onboard new clients, that many times it's commingled, and in your audits, they'll tell you clearly that cannot be commingled.
Yeah, that's a great point. You want to make sure it's in a separate account. You don't want to be, combining those things because there's lots of smart, tenant attorneys out there that will waiting to jump on an association for the slightest faux pas. So I think that's definitely a good point. I want to touch base because we get a lot of questions about this, and I think it's worthwhile to spend some time here. Okay. I would say one of the most common questions we get in the screening process, okay, because we started off with, do your documents have the authority? That's point one. If they do, how wide is that authority? Is it sales? Is it quitclaim deeds, a gift? All of those things. Then the time frame that you all have to make your approval choice. Okay, those are all important things. We talked about the transfer fees, the security deposits. So now you get the application back. You've run your criminal and financial check. Now, whether you have a quote unquote screening committee, which obviously is something that boards can do, boards can appoint a screening committee, or the board just handles this part. But we get asked a lot is, can we turn someone down? Can we reject it? And the answer, which attorneys love, is it depends, of course. But if you think about it, and I kind of want to pull back a bit, generally, the law favors property ownership and favors the ability of people to freely sell the property that they own, right? That's sort of a foundational principle in the United States. So if you think about it, an association standing in the way of that free ability to transfer property, it's a pretty serious power. And that means it needs to be used properly. So this, I like to give what our firm and most practitioners in the condo and HOA community association field typically feel is these are the common, what I call the good cause factors that a board can use. And I'll start off with the easiest ones first, okay? The easiest one is if the application on its face already shows that there'll be a violation of what your documents say. An easy example, your governing documents clearly prohibit commercial vehicles. And there's a good explanation of what that means. No commercial signage, visible tools of the trade, and you get an application, and part of the application obviously is what vehicles the applicants have. And the applicants identify 2 commercial vehicles. Well, there you have the application on its face already is demonstrating a violation. In that case, in our opinion, that's likely good cause to reject that applicant. All right. So that's, and easy one. Another somewhat easy one, another good cause factor, is if there's a material misrepresentation on the application itself. Someone lied, okay? This does not mean it's incomplete. If you get an incomplete application, you should ask the applicant to complete it, right? So I'm not talking about an incomplete, I'm talking about where someone lied. For instance, in the employment history, they wrote down they were a senior loan officer at a bank for a long time. The background company verifies the employment. The bank says they were a bank teller for a month. You know, that's a pretty big misrepresentation there. And that likely could be a good cause factor to deny someone as well. All right, so those are two of somewhat of the easier ones. I want to talk about two that we get asked about the most. One of them is the criminal history, okay? And it's mentioned in your outline. HUD, which is the federal agency that deals with discrimination complaints, HUD has come out with their views on what would be considered housing discrimination. And they came out with some good tips for communities on using criminal history as a basis to turn someone down. And essentially what HUD has said, and this is the advice we generally give our clients, is the criminal history must be a felony conviction or a felony guilty. Someone pled guilty, okay? It cannot be a misdemeanor crime. And it can't be just charges of a crime. In this country, we're what? We're presumed innocent.
Yeah.
So lots of times charges are brought and either the state attorney will reduce those felony charges or they'll enter into some sort of plea agreement, or oftentimes they'll just drop those charges. So the criminal report you get, the disposition, that's the fancy word for how was the case, how did it wind up? You need to know what the disposition of that criminal case was. And if you're thinking about using criminal history, you need to see a felony conviction there, okay? And it's not always a black and white thing where we see a felony conviction, we're automatically turning them down. You need to evaluate how long ago it was, right? What the rehab was. You know, there's a strong argument for someone that has a felony conviction 25 years ago who has paid his or her debt, whether they served jail time or whatever it was, and they've been a productive member of the world since, and everything else checks out fine. That person might be a great, new owner. Okay, so it's not an automatic thing. So if you're thinking about turning someone down based on criminal history, we suggest getting with your association's counsel to make sure you're not inadvertently, running afoul of what the HUD guidance is, because someone could make a discrimination claim based on the impact that your denial had on a protected class.
And,
So
and
it's
if I could jump in here, Andrew,
Sure.
because I think you bring up an excellent point, and it's important. And I'm sure there's a lot of managers on the call, and from the management side, I understand that they deal with certain challenges, but it's important that we keep that in mind, that these decisions of whether you're going to deny or if you're going to deny someone, it should be done with your industry expert. And your industry expert in this case is going to be your association attorney. Whether it be KBR, whoever it is. This is something that once you see that there's a felony, that they've been charged with that, if you're a manager, you need to start making that phone call with your attorney, because the last thing you want is this responsibility to fall on your hands. And as board members as well, remember, you have the business judgment rule that you should always be using when making your decisions. And what that business judgment rule says is that your policies are going to cover you and going to protect you as long as you were following the business judgment, which is in this case, contacting your attorney, not relying 100% on your manager to make that decision. It's to work with your attorney and then go over those things together and get a legal opinion of what direction you as a board and management should take with this particular applicant. I can't tell you how many times, we get put into that position, and sometimes it's very difficult, right? You have to understand that boards can be a certain way, and we understand that we're working for nonprofits and they want to save. But if you get HUD involved with any of these lawsuits, the cost of just of that damage is going to supersede the cost of 1 hour or an hour and a half of the attorney. Further, you're going to have to pay deductibles and everything that goes around that. And HUD does not play around with these kinds of situations. I mean, you can ask your attorney to pull case studies and they'll show you that they don't play around with these kinds of rejection letters. So I wanted to point that out there.
Yeah, no, I mean, those are all great points. And that's why I kind of started off by going way back to say that property ownership and the ability to sell and transfer it is a pretty well vested, right.
Correct.
So if you're going to turn someone down, you really want to make sure you're on solid ground. So that's criminal history. And the last one, which we get asked a lot, is financial history. Okay. The negative financial history could be a good cause factor. It's outside the scope of today, and I'm not going to answer specific fact patterns. Oh, this guy has a credit score of this and this and this and this. Obviously, the more evidence there is of a negative financial history, the more solid basis there is that you have good cause. If there's a foreclosure history, that certainly is good evidence to have. If there's prior bankruptcy filings, that's certainly a good indicator of perhaps a negative financial history. We get asked a lot about, can we adopt a minimum credit score? And my answer is you can, if your documents allow you to have, sale approval authority. In my view, credit score should just be one factor, and you're reviewing the totality of the application. And I say that because I've seen fact patterns, and again, these are all got to be evaluated in a case-by-case way. I've seen fact patterns where a board, let's say they had a 700 minimum credit score. Someone wants to buy, it's an all-cash deal. There's no bank involved. Their employment history is wonderful. Their prior history where they lived is great. Everything checks out. Their bank accounts are flush. The only issue is their credit score, for whatever reason, is a couple points below that. I don't think it's a great idea for the board to adopt a policy that you automatically reject based on that credit score. I think it should be one factor that is reviewed exactly for that reason there. Okay. Again, with financial history, and we even have some clients that adopt these debt to income requirements, you should be discussing your financial criteria with who? The industry expert, your accountant. Get with your financial professional. He or she would know what a appropriate financial criteria would be for your community. It's not one size fits all. The market value of the homes in your community is not going to be the same for somebody else. So if you want to use financial criteria, get with your financial professional. But again, on the credit score issue specifically, I think it should be one factor. Also, and different legal practitioners have different feelings on this, and there's no case law in Florida that I'm aware of on point. But in my mind, financial criteria is more appropriately utilized for a prospective owner versus someone who wants to rent. And the reason is the prospective owner has direct privity with the association. They're the ones that have to pay the assessments on time. Yes, I know if an owner doesn't pay the association on time, both the statutes for condos and HOAs allow the association to collect the rent from the tenant directly. So I do know that sometimes the financial ability of a tenant may come into play. But if you're asking me what is financial criteria better used for, in my view, it's for a prospective owner. These good cause criteria, these 4 or 5 things I spoke about, we prefer, if your governing documents, your declaration spells it out. You definitely need approval rights there. We prefer, if you're doing amendments, you should add this there. If you're not going to amend your documents for the good cause criteria, but you do have approval rights, at a minimum, the board should be adopting these good cause criteria to explain the approval process. And you really should be adding it to the application that you all have. That way, someone who wants to buy, someone who wants to rent, they know what those criteria are. So it's very important to have those clearly adopted. So I wanted just to spend some time on that. Also, we'll get to questions in a second. I just wanted to, give me 1 second. Just real quick. For Broward County and Miami-Dade only, perhaps Palm Beach and other counties may adopt this, but Dade and Broward, they do have an ordinance on approval. And it says you must tell the applicant what your decision is within 45 days. Now, I talked about earlier, most documents will have that time frame already in there, and it's oftentimes less than 45. So you want to follow what your governing documents say. If for some reason your documents have approval authority, but they're silent on the time frame, and you're in Broward or you're in Dade, make sure you follow that 45-day period. Also, for Dade and Broward, this ordinance says if you're going to deny someone, you need to give the specific reason why. It does not define how specific you need to get. You want to get with your association's attorney on this. In our view, the specific reason could be negative criminal history. You don't need to say you were convicted of a felony in 2017. Here's the, I think negative criminal history is specific. And this really goes on to my next point, which is you want to make sure, and this is in the statute, any information that you as an association obtain in connection with the sale or lease approval process, what they're talking about is the background report. That's got to be kept private. That's a confidential thing. So while you keep it in the records, owners don't get to see it. So just make sure you're aware of that. And with that being said, I think we can jump into some questions here.
Sure. Excellent. So I'll go ahead and do that. One thing I did want to touch up on before we get into the questions is actually, Andrew, if you don't mind, if you could make me the host that way.
Yes, absolutely.
Great. So while Andrew does that, one of the things I wanted to touch up on, while probably a lot of the managers are already using this system, there are, again, because of new accounts that we've taken on that we've noticed are not using tools that are available to them to make this process much more streamlined. So there's companies out there that'll do the entire application process for you online. And that's going to make it much more streamlined, not just for the board, but also for your manager. Time is money. So you don't want your manager or your assistant, whoever you have in your particular premise, having to deal with all this paperwork and having to put all this information together. There's organizations out there that make it completely streamlined. You could put the criteria that Andrew mentioned as the first page. They'll have the ability to fill it out all online. They'll be able to upload all the necessary information, collect security deposits, and to make things even more streamlined as a board and as a manager, if the manager has an ability of looking at it and approving it, the board can also make the approval online as well. So if you don't have an interview committee, you could approve it online automatically and getting that person done. The way we see it is we try to shorten that time frame of the approval because again, an owner that's renting their unit or selling their unit, you want to make the transaction as smooth as possible for them. Anyone that's coming in new, you want them to have a nice experience to move into your community. So again, if anyone wants additional information, I'll be more than happy to share who we use, and feel free to reach out to myself. But again, there are systems out there that allow you to make this process much more streamlined for your association, and then saving you money on not having your manager focused on receiving and emailing applications. So I wanted to mention that. Okay, I do have a question, Andrew, that was interesting. Is can they ask if someone was married? If someone is married, sorry.
Right. So, I mean, I'm not sure sort of what the purpose of that would be. You know, I think you're able to identify who the occupants are. I think you absolutely have the ability to know who the intended occupants will be. And certainly if it's a sale, you can get a copy of whatever that warranty deed is, or whatever transaction, whatever document there is. But I'm not sure I would know what the bona fide reason would be for the board to really get involved in those types of things.
So I think they're probably asking the question, Andrew, is, you know how if they're married, you only charge one fee. You can only charge now $150 if it's a condo.
Sure.
I know in some cases you'll run across where two individuals, they don't, the wife or the partner didn't take on the other person's last name.
Right.
So they do come across that instance where they kind of have to ask, are you
yeah, and I would sort of ask it in those terms. And this kind of is a nice segue, because I saw 3 or 4 questions on the transfer fee. Whether you call it an application fee or a transfer fee, it's the same thing. And what the law says is, for condominiums, $150 is the maximum. For co-ops as well, if we have any co-op people out there, under 719 of the Florida statute. So $150 is the max. That includes whatever background company charge you have to pay. So if your background company, and you're a condo or a co-op, if they charge you $200, you can only ask the applicant for $150. The other $50 is just a common expense of your community. For HOAs, and I should highlight this point, HOAs under Chapter 720 of the Florida statutes, they don't have similar transfer fee cap language there.
That's correct.
So you need to go with what your governing documents say. Because remember, whether you're an HOA or a condo, you can't charge a transfer fee, whether you call it an application fee. You can't charge it unless your governing documents say that. But for HOAs, there's actually no cap. So if your governing documents say an HOA can charge a $200 transfer fee, in my view, you would be allowed, if you're an HOA, to charge that $200 sum.
Correct. And that's why they increased the fee. It was a battle for a long time up with the legislatures, and they finally permitted it. And they also allowed, I believe we can't raise it for 2 to 3 years, but then after that, it can kind of go on to the CPI rate.
Yeah, the consumer price index, I think it's a 5-year period. So it'll slowly increase as time goes on to more accurately reflect what the market conditions are. But Raphael's right. Those people that are out there to learn how the sausage is made and to get these laws changed, it's a pretty wild thing. So it was a knockdown, drag out fight just to get this extra $50.
Yes, it was. So I have a great question here, Andrew, from Doug. And he asked, what control does the board have regarding the death of a condo owner and the subsequent inheritance of the condo by their heirs?
Great question. And that's what I call a document specific item. And I talked about a little bit when I first started. You need to review what your documents say regarding approval and how wide that approval authority is. Some documents are silent. Some documents only allow lease approval. Some documents allow sale and lease approval. And some documents are very broad and allow the board to get involved with any transfer of ownership at all. And that would include that fact pattern where an owner passes away and someone via a will and inheritance and heir, but they get title to that property. And there's some documents that do allow the board to approve that, or at a minimum, to approve who the occupant of the unit will be. Perhaps they don't approve the actual change of record ownership when someone passes away, but they allow to approve who will be actually residing there. So that is a document specific thing. So they would need to get with their association's counsel to see how broad that authority is.
Correct. Excellent. And if I can add to that, like one of the things that I've noticed that makes it much easier for management, and again, trying to bring efficiencies into managing associations, it's having an understanding what the criteria is to deny somebody. If you have that criteria ready and that person doesn't meet any of those markers, you could delegate that responsibility to a committee and whatever, just move forward with the approval process and not have this back and forth creating frustrations. So that's something that you should definitely get together with your association attorney to put that criteria together to make sure that criteria gets put into a rule or an ideal situation into your document, so you get it voted in, would probably be the best way. I have a question here from Randy, and it says, can the board get a credit score minimum requirement?
Yep. And the short answer is, if you have approval rights in your documents already, I do think the board has authority to adopt financial criteria, as we spoke a bit about before, and that it can include a minimum credit score. But again, and this is my view, credit score should be one factor. It should not be an automatic, they're 1 point, under. So, get with your management, get with your counsel to make sure that those criteria are clearly outlined. But yes, the answer is yes, the board can adopt.
And if I could provide a tip, because I know we have only one association has a credit score, but you have to also detail, again, ideas are plentiful and they're great, but it's the execution of that idea what really makes an idea come together or realize, look, this is not good for us. The question you need to ask yourself is, there's 3 credit agencies. Which credit agency are you going to use? Because you see it across the board. If you pull your own credit score, you may have a 700 with one, a 705 with another, and a 750 with experience. So you have to ask these questions. But I agree with Andrew 100%. It really shouldn't be, if you don't meet this score, it's not in. It should be that part of the criteria. I have an interesting question here I've never been asked before, is can you require cash sales only?
In my view, only if your governing documents are amended to specifically state that.
Yeah.
To me, it would be outside of the board's rulemaking authority. And even if you can amend your documents, if you think you have sufficient owner approval, sometimes older documents even have language buried in the amendment section that says any amendment that would maybe impact a bank's interest, if there are outstanding mortgages already, sometimes the banks even need to approve amendments like that. So I know in the co-op context, and this is a little outside of what we're dealing with today, co-ops, I have seen bylaws in co-ops actually they don't allow financing, right? Because co-ops is a different ownership structure. You actually don't own the physical real property. You're a shareholder. The corporation owns the entire thing. So co-ops, I think that's a bit more, I have seen that, but I think condos and HOAs, I have not seen that. And your documents would be needed to be amended. What I have seen be amended, and owners have voted in favor of this in certain communities, is the maximum amount of financing that an owner can place against his or her home. So that encourages owner to have a little bit of their own cash into the deal, right? So, so that's not quite the same as all cash deals, but I have seen amendments where you restrict the amount of financing placed.
Correct. And I have seen it in co-ops. You're right, Andrew. I have seen it where it's all cash. But as a board member, you also have to keep in mind one day you will sell your unit, or someone will inherit it and may want to sell it. So you have to keep in mind the marketability of that unit as well. Restricting your property to just all cash buyers is going to make you a very small pool. Now, maybe if you're living in a Porsche building, doesn't matter for that, that sector. But again, you have to take multiple factors into play before, all of a sudden making these certain rules and restrictions within your documents. I have a question here from Linda. Linda asked, can a non-board member be on the screening committee?
Sure. That's a document specific thing. What I will tell you is most documents don't have any sort of board member requirement to serve on that type of committee. So I'm going to venture to say it's probably okay, but of course I can't give any formal confirmation unless I've reviewed what your governing the documents say. But oftentimes there are non-board members involved. And in fact, for the fining committee or the grievance committee under the state statute, if you do have that and you want to assess a fine against someone for breaking a rule, those committee members have to be non-members of the board. So,
okay, excellent. I have a question here from Warren. He's asking, what are capital contribution fees? So I'll kind of address, I know HOAs have it in their documents, and they have to outline that fee is able to be charged. In most cases, what we've seen is they'll say that the board has to take a formal vote on what they're going to charge their capital contributions. I know that I see it a lot in HOAs, and when we take on new accounts, and it baffles me because they've been losing this income for so long. So if there's any homework that you take away, if you're an HOA board or an HOA manager, is look at your documents and see if it permits a capital contribution, because if it does, that's your opportunity to gain some additional income for your association. So what the documents will say is that you can permit a capital contribution. Most of our associations will do anywhere between 3 to 6 months of maintenance fees. And whenever there's a closing, that owner will be made aware that there's a capital contribution of whatever the dollar figure is. And then that person needs to pay in order to get into the association. It's my understanding that I've only seen in HOAs. I don't know if you want to add to that, Andrew.
Yes, no, you definitely hit on a lot of the key points. And the main thing is the governing documents for an HOA need to have the capital contribution requirement. It can't be just a board made rule. Correct. Sometimes the original developer of some of the newer HOAs, they may have language there, but your documents need to say it for HOAs. For condominiums, what the state of Florida has said is that condos cannot charge a capital contribution, even if the documents are amended. I personally don't agree, but it doesn't matter what I think. The state of Florida says for condominiums, they restrict any fee that an association charges. They restrict it to that transfer fee, whether you call it an application fee or a transfer fee. And it's $150 cap. So anything else, including a capital contribution for condos, the state of Florida says no. But for HOAs, as long as the documents are amended, that would be a valid charge.
Okay, excellent. I have a question here from Sharon. Sharon asks, our management company manages both our master association and our sub-association. Can they charge a fee to new residents for both associations? I'm assuming it's for applications.
Yeah, and again, that's a document specific thing. If the master association, because they're its own corporate entity with their own set of docs, if the master is involved in the sale or rental application process and their documents allow a fee that's authorized. In the same token, if the sub-association docs say they're involved in the application process, they can charge a fee. I can share with you, practically, I haven't seen it too often where someone wants to move in and both docs allow a separate application fee and both associations charge it. Is it possible? Yes. Practically, I don't see that a whole lot. And maybe, you all have seen it from a property management perspective. Yeah. It's relatively rare.
Correct. Yeah, it is. It really, again, it depends on the documents. It is a little bit rare, at least for the application part, because normally the sub associations would have that authority. I have seen where certain, there was one master that got all the subs to say, you know what, we want the master to address this responsibility. And they swapped the responsibility over to the master. I have a pretty long question here. So it's from an anonymous. It says, Winston Tower 600 in Sunny Isles.
Well, let's just not
indicates-
name condos.
Yeah, thank you. Yeah, yeah, that would probably be a better idea. Basically, it's stating that the declaration and bylaws that it's okay to lease a minimum, lease and rent for a minimum of 4 months. The
Right.
condo office manager informed me that you need to wait 2 years after purchasing and a minimum of 365 days.
Right.
I told them I don't see any amendments to the books approved by 75% of the owners. I checked very well online and asked them to show it to me. Manager showed me minutes from a meeting approving the changes, but none of the owners knew about it.
Okay. So let's talk hypothetically here,
Yeah,
right?
yeah.
So if an association wants to restrict someone's ability to rent for a certain number of years after they acquire ownership, I've seen it whether you need to wait a year or wait 2 years. I've even seen 3 years. That rental restriction, the governing documents need to be amended. And almost always that requires an owner vote. So it can't just be a board made rule. It needs to be presented to the owners and the owners need to vote on it. And there's actually language that's a little outside of the scope of our course today, but there's language in both 718 and 720 now. 720 was actually just changed as of July 1st, that those types of amendments restricting, let's say, when an owner can rent, those aren't enforceable against owners that don't vote in favor of it. So there's lots of sort of fact patterns that are arising from this question. If you're an owner out there, our firm is actually on the association side, I would say 95% of the time. But if you're an owner out there and you feel like the association is improperly enforcing a rule and you haven't received a satisfactory response, obviously the goal is to try to amicably work these things out, maybe send a certified mail, asking these questions. But ultimately, you could either contact the state of Florida if you're a condominium, or even perhaps engage your own personal attorney to help you all out. But those types of leasing restrictions, you have to wait a certain number of years. That is something that your governing documents need to be amended for.
Correct. Excellent. So we have a few minutes here. I'll go through a couple more. It says with regards to, let's say, again, back to the credit score. The question was, what happens if the person is international, which that's something that's very common here in South Florida.
It's very, very tough. There are background companies out there that I do know that do international checks. So I think that is an avenue that's available. You could still ask for bank account information. You could still ask for employment information. I do think the board has the ability to evaluate, if you're buying, what type of financial resources you all have. So, you want to be very careful, of course, because one of the constitutionally protected classes is national origin. So you don't want to be saying, well, we just had trouble getting a credit report, so we're turning you down. Yeah. We would certainly advise against that. So, definitely get with your association's counsel if you have a particular application question.
And that goes straight to your point, Andrew, that you were saying earlier, that it needs to be one of the criteria, not the criteria, because correct. that we do see as well. So we're getting close to 12. I'll leave this last one here from Luzbel. And her question is, if the new ownership is an heir, do they have the same rights as the original owner that is deceased? Do they get grandfathered in, let's say, for the rental if there was a change? And she says there was an amendment to the bylaws in regards to rental. If the new ownership takes over after this date, would that mean that they are not grandfathered in?
Right. So she asked a very good question, which unfortunately you would need to have counsel review the exact amendment language, which hopefully, if it was drafted properly And if it wasn't drafted properly, it wasn't our firm, of course, but it should address those fact patterns as far as how you apply whatever rental restrictions you all have, whether it's an heir or not. Once record title is in that individual's name, certainly from that date forward, they pay assessments just like any other record owner would. Whether that rental restriction is enforceable against them, I think you would really need to review what the actual amendment language is.
Okay, excellent. So we still have a ton of questions here, but I want to be respectful of your time, Andrew. We're right up at 12 o'clock. Is there any closing remarks or anything you want to wrap up the webinar with?
Yeah, so I want to thank everyone again. Raphael, thank you as well. A lot of the questions, because I've been kind of scrolling at them, we're not ignoring you.
Yeah.
I promise. Some of them are very fact specific. So again, this was for general information. Hopefully you got a flavor of how the screening and the application process works. We definitely encourage everyone to attend, lots of our upcoming courses. And please do also, this is one important thing. I believe there'll be a survey sent to everyone here today. Please do, especially if you're a manager and you want your credit, obviously, but please do take the time to fill that survey out. We actually read every single one, and we really appreciate whatever constructive feedback you all have. Our goal is to give free education, right? So we want to hear from you all. So if you loved it, tell us. If perhaps you didn't love it and the reason why you didn't love it, we want to know that. We're never a finished product here. So please do take the time.
Excellent point. Thank you, Andrew. And so many questions that came up on the Q&A was, will this be available online? So if I can ask everybody to pull out their cell phone, you can go ahead and use this QR code. Nowadays, everyone knows how to use a QR code. We will be posting the video within the next 24 to 48 hours on our YouTube page. So make sure you subscribe to Affinity's YouTube page. We have a ton of information. The reason why we work so well with KBR and Andrew and his team is because we both have the same vision, which is basically educating our board members and our clients alike and making sure that everyone understands, what goes on within our world. I wanted to thank everyone that's here today, both the managers and board members that are attending. I wanted to thank both KBR's team as well as my team, Ashley, behind the scenes, putting this together. They make us always look great, so it makes it look simple, but there's a lot that goes on to put these webinars. So again, as KBR mentioned, as Andrew mentioned, there will be other webinars. Please feel free to reach out to any of us if you have any questions. Thank you again for attending today's webinar, and we'll see you at our next one. Have a great day.
Thank you all. Take care.
Bye-bye.